Good afternoon. The first case of the call this afternoon is Honigman, Miller, Schwartz versus the City of Detroit. This is a calendar case, but I believe the court has ordered 20 minutes of argument per side.
Thank you. My name is Charles Ramey. I'm the Deputy Corporation Counsel for the City of Detroit, and I'm representing the city. I'd like to reserve, if I could, 3 minutes for rebuttal.
You may, but you will have to try and keep track of that, and nobody has succeeded yet. So
I doubt I'll succeed. So.
Okay.
This case involves legal services performed by Honigman firm lawyers in the City of Detroit. Those might be drafting a brief or arguing a case in circuit court or drafting a contract in the City of Detroit. Under the plain language of the statute, those are, quote, services rendered in the City of Detroit and are properly included in the numerator of the revenue factor of the three-factor apportionment formula. The Court of Appeals held that those are not services rendered in the city unless there is some sort of physical delivery of something in the city. The court never paused to consider the plain meaning of the words of the statute. The court ignored the fact that the phrases services rendered and services performed under both common usage and every reference available are synonymous terms. The court clearly erred in giving those synonymous phrases, which don't contain any words of art, different meanings. And in fact, the court held that they had to be given different meanings. Even more fundamental, applying a concept of physical delivery makes no sense when we're talking here about intangible legal services. If a firm lawyer prepares a brief in Detroit and the bill for that time spent is $10,000, the $10,000 reflects entirely the time spent and the effort and the skill of that lawyer exercised in the City of Detroit, services rendered in the city. The piece of paper that ultimately embodies that brief has no intrinsic value whatsoever. That for pennies, that brief could be copied and sent to hundreds of locations around the country that have the economic value and give that value. For commercial transactions, the firm lawyer may often not even know at the time when the services are being rendered where the final piece of paper may end up. There may be a closing in the firm's Detroit office. There may be a closing in the Detroit office of opposing counsel. There may be a closing in the suburbs. Or there may be no closing at all because the transaction might fall apart.
Mr. Ramey?
Yes.
I found one provision within the entire act at issue that uses both rendered and performed in the same sentence. That's section 13A that states that the tax on a non-resident individual's income includes salary, bonus, wage, commissions, and other compensation for services rendered as an employee and other compensation for services performed in the city. Can you explain why the legislature would use these different terms within the same sentence if they're to be treated synonymously?
Thank you, Justice Markman. I think the legislature just viewed those terms as synonymous. And in fact, we cite a case in our brief, and the name is...
Doesn't that suggest to the contrary that they would be both used within the vicinity of the same sentence and literally in a neighboring clause?
Yes, and as I mentioned, there's a case in our brief that involves a criminal statute, and I forget the exact words, but it said, I can't remember, but it was or. The words were separated or. But the Supreme Court said that those words were synonymous, and they should not be given different meanings.
Well, that's a conclusion, but as we try to reach that conclusion, I'm looking at this provision, this sentence, and I'm wondering why, if that's the right conclusion to reach, they would use these alternative formulations within adjacent clauses. You follow what I'm saying?
Oh, I absolutely follow. I think the answer is that, as I said, I can only conclude that the legislature simply viewed those terms as synonymous. And just like lawyers often say, ordered, adjudged, and decreed, that's why they did it. In my view, it has no significance to the determination of the legislature's actual intent here.
Mr. Ramey, I want to sort of think about what Honigman is selling. So I take it your view is, because I think the statute is entirely clear, that if a business in the city of Detroit was selling widgets to a client in Ann Arbor, the University of Michigan is buying widgets from a city of Detroit business, those widgets, because they're sold in Ann Arbor, don't get counted under this factor. Is that right?
So you're correct, but I just want to make clear that the statute carefully distinguishes.
No, I know. I'm going there. You're with me. I'm glad.
Okay.
So it's really easy if it's widgets.
Right.
If it's a Detroit business that fixes dishwashers, and they fix dishwashers, turns out this year only in Ann Arbor. Everyone in Ann Arbor needs their dishwasher fixed, and they go fix the dishwashers in Ann Arbor. You guys at the city of Detroit don't think they have to count the services rendered fixing dishwashers in Ann Arbor for this factor, correct?
That's absolutely correct.
Even if they did a lot of research on what the dishwasher fixing needed in their Detroit business, and they gathered the parts and the tools in their Detroit business because they showed up in Ann Arbor and did the actual fix, you think that's not covered, correct?
I think it depends on what the customer is billed for. So if the customer is billed for the time in Ann Arbor, then I think that's clearly services rendered in Ann Arbor. If the customer got a separate bill, and I can't imagine they would, for whatever time somebody spends in Detroit doing research, and I would hope that if I call somebody to fix my dishwasher, they really don't have to spend a lot of time in their office doing research. I think that the time would be spent at the scene fixing the dishwasher.
So you really think it's where the business does the billing, not where the client gets the benefit of either the goods that are delivered or the service that, of the goods that arrive or the service that's delivered? You really think it's where they do the billing? Because I thought that was what you took issue with in the...
No, it's what they're billed for,
Okay.
not where they get the billing.
Right.
It's what they're billed for. So if they're
I think I agree with that. So if what they're billed for is whatever the thing is that Honigman is selling, and I'm not myself sure that it's, I know we say legal services, but I think of big law as being in the business of law sales. They're out there like selling law to people. If they're selling law to the University of Michigan, or they're rendering legal services to the University of Michigan, because the University of Michigan needs some advice on updating their, say, policy on, speech, and they go to Honigman because they think Honigman has, lawyers who can advise them on that. The University of Michigan benefits from what they've bought from Honigman, whether it's advice or service or how, law sales or law services. They're benefiting from that in Ann Arbor when they then change their policies and their handbooks and teach their deans. I mean, they benefit from what it is they bought where they are. Why isn't that an easier, clearer way to think about this factor?
Well, I think that's really a completely unworkable way to think about it. And I'll give this example. A commercial transaction, and I think I just mentioned that. There's no way of knowing where that final document is going to end up.
Doesn't matter. Where does the client who bought the document, who bought the transaction, who bought the law, where do they benefit? Where is their business such that they benefit? That feels easier than where somebody did the work. I mean, I understand that Honigman has like crappy offices. I'm not saying that I think they're crappy. They might be really. I hear they don't invest a lot in their offices because, and that's the people say that about Honigman. No offense, Honigman, and people might not do work in those offices. They might do all their work in their Ann Arbor home. Under your rule, do they have to keep track of where the lawyers do their work?
They do keep track of where their lawyers do their work.
And that's how you would have them
Yeah, that's
tally it up?
exactly how they do it, and it's exactly consistent with the statute. Every lawyer, every day, makes a daily time report of exactly where each service is rendered, whether it's in the city of Detroit, whether it's in the Troy office, whether it's in some other office. They make no attempt to divine or record where any work product may end up. If it's in the Wayne County Circuit Court, they don't make any attempt to do that. They put down exactly where.
Well, they know where their clients are and where their clients are located, but wouldn't your rule incentivize them on their most expensive deals to say, hey, lawyer Smith, make sure you do all your work at your home office in Saugatuck so that we don't have to actually pay any taxes on any of this work?
We're happy to have that situation, if that's what they want to do. That we're delighted with that, because they do have a Detroit office. A majority of their attorneys work out of the Detroit office, and those services rendered in Detroit is what generates the billable hours.
Is that calculated under the sales factor or the payroll factor, that they're keeping track of where they're performing the work?
Okay. We refer to it as the revenue factor because that's how it's referred to in the statute. I know the firm refers to it as the sales factor, but that's under the revenue factor. The payroll factor is completely different. And I know the firm has raised the argument that these three factors are intended to measure different aspects of the firm's business. The short answer to that is that the three factors are intended to measure exactly what their plain language says they're intended to measure. But the payroll, in this case, the payroll and the revenue factors measure demonstrably different things, because what somebody is paid in payroll is necessarily different than the revenue they generate from services rendered in the city. And I'll give you some really powerful examples. For example, firm partners don't get any payroll. They get a share of the firm profits. So they add zero to the payroll factor, but obviously for the services rendered in the city, they add considerably to the numerator of the revenue factor. You can flip that around for infrastructure employees, like their chief financial officer, chief investment officer. They add zero to the revenue factor, but they add considerably to the payroll factor. So those are two very distinct factors, and we have properly accounted for those under the plain language of the statute.
Mr. Counsel, I shared with you my ponderings about the meaning of Section 13 a few moments ago, the section that contains both the phrases services rendered and services performed alongside each other. I also pondered just a little bit Section 23, which concerns the sales of both goods and services. And it's clear when you look at the illustrations that follow in that provision that that factor looks to the destination of where the goods are delivered. Why wouldn't common interpretative sense suggest that we also treat services in that same section in a similar fashion?
So I think that that is strong evidence that the two things were to be treated differently. And again, it gets down to the fact
What is the strong evidence of that?
that the legislature felt it necessary to spell out in detail where physical goods were delivered for purposes of income tax.
Do you think that specificity outweighs the fact that both of these kinds of sales are addressed in the same provision again?
Well, I absolutely believe that, because the phrase services rendered in Detroit was viewed as the legislature as being self-explanatory. Whereas when you're dealing with physical goods, delivery has independent legal significance. The value of a good is embodied in that physical product. Whereas, and again, as Abraham Lincoln said, a lawyer's time is her stock in trade. And that, in this case, I believe is very appropriate, because that ultimately, Chief Justice, is what Honigman is selling, is their time. And that is why services rendered in Detroit must mean time spent in the city of Detroit performing legal services.
But you understand in both the provisions that I've raised with you, the factors that you look as supporting your position, the city of Detroit's position in this case, are likely, I'm speculating, but they're quite likely to be cited by opposing counsel as clues that conduce in favor of the exact opposite result.
I know they have made the argument about the sales of goods, but to me, when the legislature felt it necessary to specifically address examples for sales of physical products, that to me suggests that the legislature felt that was completely different than rendering of intangible services. And legal services are intangible, and they're necessarily different in every way from the physical product. And I'd like to make another point, which I think is perhaps very telling on this subject. And the Court of Appeals did not adopt the hypothetical, Chief Justice McCormick, that you suggested about where the benefit is rendered. They adopted a physical destination test. And they suggested that if there were a lawyer from the Honigman firm was arguing a case in Wayne County Circuit Court, of course that would be services rendered in the city. And at oral argument, the firm's counsel specifically said, yes, when we have one of our lawyers arguing a case in Wayne County Circuit Court, of course that service is rendered in the city.
I saw that. I'm going to ask them about that.
But then their affidavits say precisely the opposite. And the sole controlling factor for the firm is how where they decide to send their legal bills. That trumps everything else. If client comes in the door and they code that client as being in Southfield to send their bills. Now maybe that client has offices in and outside of Detroit, but wherever they decide to...
The choice isn't like what Honigman says or nothing. We're trying to figure out what the statute means. And so that we're just trying to give, meaning to the words the legislature selected. So,
Well, I just will suggest this, that the firm is asking this court to adopt a construction of the statute that, in my view, is contrary to the plain language services rendered in the city, is completely unworkable because the firm at the time the services are rendered won't necessarily know where any work product may end up. And it's contrary to the firm's own procedures, which I think is important in this case. I see I have 2 minutes left.
You're winning so far. If you could sit down right now, you've reserved 2 minutes.
All right, thank you.
And 8 seconds.
Good afternoon, and may it please the court. Len Niehoff on behalf of the Honigman Law Firm. With me today are my colleagues Lynn Gandhi and Robert Riley. Permit me, if I may, to cut to the chase. The city wants to rewrite the statute that is before the court, and in fact, the city wants to rewrite it not just in one way, but in multiple ways. And I'd like to begin by pointing out the principal ways in which the city would like to perform invasive surgery on the statute that is before this court. First, as has already been observed, Section 623, the third factor in the apportionment formula, uses the words services rendered rather than the words services performed, which we find in Section 622, the second factor. The city wants to rewrite Section 623 so that it uses the same words as Section 622 and also says services performed, even though the legislature plainly chose different terms that have different meanings for Section 623. Second, if you look at the opening sentence to Section 623, the very opening sentence, it twice in that opening sentence refers to sales made and services rendered in one breath, signaling that the legislature clearly thought of them as identical, as functionally identical for purposes of the third factor. The city wants to rewrite Section 623 so that it applies one standard to sales and another standard to services, disconnecting what the legislature expressly connected. Third, the city wants to rewrite Section 623 so that it does not include subsection 1, the portion, Justice Markman, you were asking about just a moment ago. And the city says something rather astonishing here. The city says on page 1 of its reply brief, and I quote, "The word delivery does not appear in the statute." Again, reply brief, page 1, the word delivery does not appear in the statute. I am completely baffled by that representation because it is demonstrably and simply wrong. In fact, subsection 1 of section 623 uses the word delivery multiple times. For example, in discussing sales, it refers to the place at which delivery has been completed. The city wants to erase this substantial part of this statute from its text. Fourth, and finally, the city wants to rewrite the statute in its entirety to give it a whole new structure. The legislature did something exquisitely clear here. It set forth 3 factors that it viewed as distinct and did so counting them off sequentially. If you look at the beginning of each part, it says, first, consider this. Second, consider this. Third, consider this. These are 3 distinct parts that ask 3 distinct questions. One focused on property, one focused on compensation, a third focused on revenue. The city wants to rewrite the statute so that the services rendered part of section 623 becomes something like a subpart of section 622. This ends up resulting in this weird redundancy that we talked about in our brief, where it has section 622 and 623 sort of asking the same question, which was, where was the service provider physically located, as opposed to the question that's clearly to be asked under section 623, this question you were asking, Justice McCormick, which is, where is the benefit of the service received? This radical surgery makes a complete mess out of what is otherwise a clear and crisp statutory structure.
Counsel, in response
Yes,
to
Ron.
one of my questions, Mr. Ramey indicated that these terms, services performed and services rendered, were essentially chosen by the drafters as basically being selected from a thesaurus. They meant essentially the same thing, and they were adopted and placed within the statute in various positions. To use your terms, however, isn't it at least arguable that these terms are used in an exquisitely clear way, in the sense that the term performed is invariably used when it's referring to the employee's actions for the employer, while section 23, which uses renders, invariably relates to the taxpayer, that is Honigman, rendering services for a client. Aren't these terms, albeit distinctive terms, used in disparate contexts, but not necessarily communicating anything different?
Your Honor, I would have two answers to that question, if I may. The first is this. I think that the most the city could point out here is that the statute is ambiguous. If the statute is indeed ambiguous, we win. Because in the case of tax statutes, all ambiguities are construed in favor of the taxpayer. So the most the city could possibly argue here would be, I think the word you used, and I apologize if I'm misquoting, but isn't it arguable? If it is arguable, then the statute is ambiguous and we win.
Well, every statute coming before us would be ambiguous by that criteria. We always have conflicts and disagreements. That's kind of the stuff of what we do here at the court. That doesn't make these matters ambiguous. Both of you say it's not ambiguous. That might be the better assessment than merely the fact that you disagree with each other, hence it must be ambiguous.
Having failed to persuade you with my first point, Justice Markman, let me go on to my second, which is this. The word rendered simply means something different. And this is not only reflected in the dictionaries, and I appreciate the fact that my opposing counsel found some other dictionaries that say something else, but the word rendered actually means, it has a very specific meaning. And when the legislature chooses a word that has a specific meaning, I think the court has to credit that. The one thing that all the dictionaries have in common is they point toward a Latin root. And the Latin root, redere, means to give. to hand over, to, in essence, to deliver. So whatever other disagreements may exist among these dictionaries, everyone agrees that in a precise sense, what these words mean differs. The other point, Justice Markman, and it relates, in one of your opinions, I apologize that I can't remember the name of it, you used the phrase context matters. And so we don't just look at the word rendered in splendid isolation. We look at it in the context of the rest of the statute. And I think that when we do that, everything else about the statute reinforces the idea that rendered has a different meaning here, that rendered has the same meaning that is applied to the sales standard here, which is where's the benefit
Can I follow
received?
up on that point?
Yes, Your Honor.
Look, the whole argument, everything, words matter. That's the theme of this, right? And in 141-623, it states in the first sentence, third, the taxpayer shall ascertain the percentage which the gross revenue of the taxpayer derived from sales made and services rendered, suggesting these are two different things, correct?
Different things, but measured by, in our position, Your Honor, the same standard.
Okay.
That's why I believe that
I'm
it's important.
going to move forward now.
Yes, Your Honor.
Subsection 1, after, in the provision before subsection 1, we'll call it the heading or the first paragraph before we get into subsections, goes out of its way to twice distinguish sales made and services rendered, or sales and services. When we get to subsection 1, it says, for purposes of this section, sales made in the city. It never refers to services rendered. And then it goes on with A through E that talk about the destination. This is what the Court of Appeals relied on. I assume you like that approach.
Yes.
But if words matter, why isn't reference to services rendered right in subsection 1 of section 141 of MCL 141-623?
Your Honor, I can answer that question. Here's why.
I had no doubt.
So, Your Honor, if you look closely at subsection 1, and you understand what the work it is doing in the statute, the subsection 1 says something very specific. If you look at the section closely, it uses the word guide, and it is also very careful to say the examples we are giving here are not all inclusive. In other words, Your Honor, let's take a simple sales made. Let's say that you and I sit down in Detroit and we agree to make a sale, but you want it shipped to Lansing. Under the simple word sales made, it's not entirely clear how you would measure that. So what subsection 1 does is it says, we're going to help you understand how this statute applies. We're going to give you a guide, but we're going to tell you this is not all inclusive. Your Honor, subsection 1...
Let's follow up on that. The
Yes, sir.
following examples are not all inclusive. I agree. But it goes on to say, but may serve as a guide for determining sales made in the city. And the statute goes to great lengths to distinguish sales from services rendered. Why didn't the legislature say that not all inclusive, but may serve as a guide for determining sales or services made or rendered in the city?
Your Honor, let me say two things. The first is that as I read this part of the statute, what it is saying we're going to give you some not all-inclusive examples to help you understand how this part of the statute works. I think that's clearly what it says. That's why it describes it as a guide. That's why it says it's not all-inclusive. This subsection doesn't even answer all the questions that exist about sales. It's not even an exhaustive list of all the ones about sales.
But this subsection is about sales. It doesn't answer all the questions, but the significant point I'm trying to convey to you is that it's all about sales and not services rendered. And that's concerning to me.
But I think, Your Honor, I think that you have to ask what work this is doing within the statute. And I think that what this is doing within the statute is it is providing, I think it would be ironic where the legislature has gone to great lengths to provide an interpretive guide, to say we're going to give you a guide, we're going to give you some non-exhaustive examples to help you understand how this factor works, so that you understand we're thinking about where things go. I think it would be the ultimate irony to turn that against the legislature and say, well, even though you said it was just a guide, and even though you said it was not all-inclusive, we're going to treat it as if it were limited to sales.
Because that's what you say.
But I don't think, Your Honor, it says that it is limited to sales. It says, with respect to sales, here are examples.
All right, well, we can argue all day, but it says for purposes of this section, sales made in the city means. So in that regard, I think it's sales. But other
can
people
I
will have
ask-
questions for you.
Sorry, can I
Thank you,
ask you, so say hypothetically, if you can follow me along, that Honigman, and a Honigman attorney is retained by an insurance company who is in Iowa, say, to represent their insured, who is a Detroit business, that is sued in Wayne County for a slip and fall. The attorney in Detroit, who is serving, who has two clients, right? I mean, that's your tripartite sort of relationship. You have your client in Iowa, but your Detroit insured is your client as the attorney. And you do your research, you write your brief, you file your motion for summary in Wayne County, you win. Where does the client receive services under your calculation?
Your Honor, under the third factor, essentially the client determines where they are, where they get the benefit. That's true of sales. When a client says, send this to Lansing, they've said to us, we want it shipped to Lansing. Same thing holds true.
Which one, who is your client?
Well, so if I'm making a sale and the customer says, send it to Lansing, then that's where I send it. The client is saying, and all I'm doing is trying to draw an analogy.
Okay.
So what I would do is, under the scenario you've described, is I would say to the client, where do you want the bill to be sent? Where in essence, where are you?
Well, and that's my question, because are you providing a service, you are providing a service and getting paid by the Iowa insurance company, but the Detroit business is your client as well. And probably, I mean, your obligations, your ethical obligations, all those things relate to them at least as much, if not, more in circumstances. But so you are providing a service to a Detroit business or client and getting paid to do that by an Iowa company. And maybe it's not where they're rendered. Who is your client? And in your calculation, how would you calculate that?
The way I would think about it, Your Honor, and I haven't actually thought about this hypothetical, but the way I would think about it is I would say, the question I'm going to ask myself is, where is the actual client? That's the person who's getting the benefit of the services, so forth and so on. And if I may not know enough about insurance law to know how to sort through the ethics issues of who qualifies as the client here, but I can imagine that there might be a case where the actual client would be in a different location than the bills were sent to. But as a general proposition, the way in which we do it is we say to the client, we normally have simple models. For example, the last time I was before this court, it was representing NBC in a case. NBC is in New York. If NBC didn't exist in New York, there would be no revenue. There would be nothing to send anywhere because the benefit is received there in New York. The bills go to New York. As far as I'm concerned, I'm rendering services to the client in New York. Bear in mind that this doesn't fail to capture revenue. The partner who sits in an office in Detroit, that office in Detroit is still to some degree going to be captured by the property factor.
What about the payroll factor, Mr. Niehoff? On exactly the point you raised, opposing counsel made an assertion that the partners, you have a lot of partners in Honigman, a lot of associates, but there's a lot of partners who presumably do a lot of legal work in the city of Detroit. Is that captured in the payroll factor? Or I thought opposing counsel said since they take draws, that it wouldn't be captured in the payroll factor. So,
Your Honor, here's my understanding. My understanding is that the payroll factor says employees. So if you have a shareholder lawyer who receives a distribution, then that revenue would be captured under the third part of the test to the extent that the client is based in Detroit. But
doesn't that create an anomaly then, where the city's not being compensated for work
But Your Honor,
performed by partners in the city under either factor?
Your Honor, not only does it not create an anomaly, it preserves something that's consistent. As Justice McCormick suggested in an earlier question, if we sold widgets and we were a partnership that sold widgets and we shipped them out of the city of Detroit, that wouldn't be accounted for in the factor either. In fact, not only is this not an anomaly, But we would get a weird sort of asymmetry if the rule were different, because we would then be thinking about it in two different ways. So there's nothing remarkable about this. We would do the same thing with sales if Honigman sold widgets rather than selling law.
I mean, is it, the widget factory presumably doesn't have as many owners, you know, unincorporated partnership owners as a law firm might, right? So is it your position that the legislature just sort of missed this business structure and created this loophole that you're exploiting?
Oh, Your Honor, I don't think this is a loophole at all. I think that we have to remember
But
that there's...
it seems strange that the services performed are not captured under either factor for partners at law firms.
Your Honor, I think it's important to remember that this statute exists against a constitutional backdrop. And the constitutional backdrop is that a state can fairly apportion taxes, fair apportionment. And what we have in all of these different kinds of statutes is an effort, often
there's no
imperfect.
constitutional dimension to this statute, though, is it? Because it's all within Michigan, right?
Well, there would, but if the tax were unfairly apportioned, if, for example, the city of Detroit adopted a statute that said anytime you walk into the city of Detroit, every dollar of revenue you ever have generated then we would have a constitutional problem. So the statute can only impose a tax that's fairly apportioned. All fair apportionment statutes will by necessity be imperfect. They won't capture
Well, I agree, it's an
everything.
approximation. I
Yes,
agree with that.
exactly. It's an approximation. And what
But
we
the
have,
widget company, if they have, you know, even if they're a general partnership, presumably they only have a couple of partners who maybe don't spend a lot of time at the factory making widgets. So the labor cost there would be captured on the second factor. But it seems to me, you know, you guys have a lot of partners. So a lot of the work being done in the city is not being captured under any of these factors.
well, you know, but another way to think about it would be to say, in our case, 7% of our clients are based in the city of Detroit. 7%. Under the city's formula, on this factor, that ratchets up to 50%. So 93% of the benefit of the work that these lawyers are doing is going out of the city. The idea that under that factor, that pops up to 51% doesn't make any sense at all.
Counsel, I have a question though. Under that basis, help me to understand. I like to sometimes try to keep things simple. If this court were to write an opinion, what implications would that have on attorneys and how they bill? Would there be any change? Would there be modification? I mean, I'm hearing your argument, and your argument seems to be that this wouldn't really change structurally the billing practices of attorneys. So explain to me, like, if we wrote an opinion, what would the implication be for law firms all across Michigan?
Well, Your Honor,
And also, in reference to the Grand Rapids amicus, you know, it seems like this is quite concerning to most cities. So help me to understand, if I'm a practitioner, if I'm a lawyer, if I'm a law firm, we write an opinion, how is this going to affect people's practice of law in Michigan?
So, Your Honor, the two of the three factors are not going to be influenced here at all. So the factor that, the property factor, which might, for example, influence a law firm's decision about where to have its offices and so forth, that's not going to change based on this court's opinion. The payroll factor, the second factor, that's not going to change based on this court's opinion. So the only question would be, is anything going to change based on this court's opinion with respect to how we would do business?
You're probably going to send all your partners to Ann Arbor and Troy and have all your employees work in Detroit.
Well, you know, the question is with respect to how it might change. One of the problems that would make it hard to change is that what we're doing right now, Justice Bernstein, is we're responding to what our clients are telling us to do. We say to our client, where do you want us to send the bill? Where do you live? Where are you? And they tell us, and that's the way we think about where our services go, where our services are rendered, where the benefit is received. It seems to me extremely unlikely that we would end up being in the business of trying to talk clients into having bills go different places other than where they want them to go. That's not the kind of relationship we have with our clients.
Before you're out of time, but are you in the business of selling law? Are you selling widgets or fixing dishwashers?
Your Honor, what we do is we render services to clients.
You're fixing dishwashers. Okay.
And when they receive the benefit, and if we're lucky enough to win a case, get a good result, the champagne bottles are opened where the client is because that's where the benefit is received.
So when Mr. Pirich in the Court of Appeals said that whenever you argue a case in Wayne County Circuit Court, even if the client is in Iowa, not Iowa, let's pick a different, Justice Kavanaugh's example confused me because there was a client in Detroit, and I think if there's a client in Detroit, you're on the hook for the factor no matter what. But putting that aside, only an Iowa client, but you're defending a lawsuit in Wayne County somehow, Mr. Pirich in the Court of Appeals said, oh yeah, that would count. I don't think you agree with that.
Your Honor, if you look closely at and I am second to none in my admiration of Mr. Pirich, but if you look closely at this
You can say you got it wrong, just say it.
if you look closely at this exchange, I'm actually not going to put this entirely on him. If you look at this exchange, neither the court nor Mr. Pirich did themselves particularly proud in this exchange. The first answer he gave was exquisitely clear and was right, and then he got a follow-up question. I could literally go, Justice McCormick, line by line and show you where the Court of Appeals is confused and he is confused,
Okay.
and they're talking at cross purposes.
That happens, I get it. I understand.
It happens. It happened here. It obviously had no effect on the Court of Appeals opinion, and we're here on de novo review anyway. But I think there were simply miscommunications going on.
Understood.
I just have a question. I'm just trying to, this is just kind of goes to the conceptual nature of choice. You know, ultimately, reading the statute, reading kind of the arguments that you've put forth, isn't there some sense that that Honigman makes a determination that it wants to be based and seen itself as a Detroit law firm, right? You don't necessarily get to choose where your clients are located. So ultimately, is there any kind of essence that we should take into account where basically when a law firm determines where it wants to make its base of operations, that it's going to then subject itself to the tax tribunal or tax components that are found within those locations? If I choose to be a Detroit firm, that's my determination, that's my decision, because I want to avail myself of being a Detroit firm. If I choose to be a Birmingham firm, I choose to avail myself of Birmingham. And thus, I also am aware of the tax implications of that determination. In your argument, you don't really make a determination or a decision as where your clients are located. So I guess ultimately, like, help me to address or abate concern about determinations or decisions that law firms make when they choose their base or headquarters of operations.
Your Honor, I think your question goes exactly to the question of fairness. It goes exactly to a principle of fairness. And it does in this sense. What we have here is an apportionment statute that tries to figure out a fair way to think about the revenue that is generated, the property that is owned, so forth and so on, in the city of Detroit. So when a firm makes that kind of decision, they make a property commitment, and that's accounted for in the first part of the formula. They make personnel commitments, and that's accounted for in the second part of the formula. They will have some clients who are in the city of Detroit, and to the extent they do, that's accounted for in the formula. And to the extent that the benefits of their services go outside of the city, the formula adjusts for that. So I think that your question is, if I could rephrase it slightly, if you're a law firm trying to figure out whether to be based in the city of Detroit, the thing you want assurance for is that you're going to be taxed fairly, and it's going to be a proportional assessment. And I think this formula, properly understood, gets at that. And I think that the rewriting by the statute, by the city, actually distorts it very substantially, as is reflected by the numbers regarding our own firm.
Thank you, counsel.
Thank you, Ron.
So I'd like to focus for a moment on this question of where the benefit is received. The Honigman firm has many, many multinational clients. I'm not sure if they include General Motors, Ford Motor. NBC has locations all around the country. How in the world, in any particular case, are you supposed to figure out where, quote, the benefit has been received? The firm makes no effort to do that. What the firm does is when the client comes in the door, there's a decision made of whether to code the billing address of that client as inside the city or outside the city. Now, how they made that decision, hey, they've cloaked it under attorney-client privilege. So in discovery, we weren't able to determine for any given client that may have locations inside and outside the city how they chose any particular billing address.
But whether, Mr. Remy, whether their approximation for where the benefit of their law services or widgets are received, I'm not giving up on my law sales, isn't, really what matters. For us, we're just trying to figure out what is the best way to interpret where their services are rendered, and that isn't that hard to figure out. If they get hired by NBC and the general counsel of NBC, whose office is in Manhattan, hires them, the general counsel hired them to give her advice about how to handle a particular matter. Once she gets that advice and she acts on it in her company, we know where she's acting on the benefit of the advice. Why is, just because they may have like a poor way for figuring out where the benefit is received, why isn't that still what we're supposed to figure out?
What about General Motors, which has locations inside and outside the city? They pick one location. They make no effort to determine whether it's benefiting a GM location inside the city or outside the city.
Wouldn't we know that? I mean, sometimes Chemical Bank hires a law firm, and if Chemical Bank corporate, the general counsel of Chemical Bank hires a law firm, they're right downtown Detroit. That's easy. But maybe a branch of Chemical Bank in Ann Arbor hires a law firm in Detroit because they have an employment issue just in their one branch. Then it's that branch who's benefiting from the law firm's advice. I don't see why that's that hard.
But that's not the way they do it, and
Fair enough. They
I
might
don't-
have to revise
I
how they
don't,
do it.
and furthermore, I think when I go back to the phrase services rendered in the city, it's synonymous with services performed in the city. That's my fundamental
Yes.
argument. Let me make this last point about,
Okay.
quote, fairness. A majority, the Detroit office of the Honigman firm is by far and away the largest office it has. A majority of its attorneys work out of that office. A substantial majority of the revenue produced by the firm comes out of that Detroit office. They propose an 11% revenue factor. The city proposed a 50%, which is absolutely eminently fair and reasonable. The statute has a provision that says that if the firm thinks it's not being fairly apportioned, they can seek relief. But here, it's eminently fair and reasonable. They're in the city, they're receiving all the city services. The revenue generated by their partners doesn't appear in the revenue factor, and the share of their profits doesn't show up in the payroll factor. So we believe the city's position is absolutely fair and reasonable and consistent with the plain language of the statute. Thank you very much.
Thank you, counsel. Case will be submitted.